Welcome back to the webinar on government information gathering. This is Mike DeBliss, and I'm delighted to have you here with me in what is the third webinar in this series. We're going to pick up where we left off in webinar number 2. As you might recall, in webinar number 2, we began with the list of privileges, and the first was the Fifth Amendment privilege against self-incrimination. We covered that privilege as it relates to testimony. Now we're going to cover the Fifth Amendment privilege as it relates to document production, and then we will move on to the second main privilege, which is immunity. Now, what do I mean by the act of producing documents? I think it's important here to distinguish the act of producing documents from the documents themselves. What I'm referring to here when I say the privilege as it relates to document production is the act of producing the documents in response to a subpoena. So I'm not talking about the contents of the documents themselves. I'm talking about the very act of producing them, meaning the taxpayer or the taxpayer's accountant turning them over to the government. That act has communicative aspects of its own, believe it or not. And those communicative aspects are independent of the contents of the papers. So that's what I'm referring to here when I talk about the act of producing documents. And we're going to, in the next slide, discuss what the act of producing documents actually concedes. But what we see here at the top of this, a general rule of thumb that can guide us through this, the choppy seas of the privilege and document production. And that's that the act of producing documents in response to a subpoena may be subject to the Fifth Amendment privilege against self-incrimination. Unfortunately, as it happens in more ways than we'd like in the law, there are a lot of gray areas. And as great as it would be to fashion a rule around the act of producing documents and say definitively that any act of producing documents in response to a subpoena is always subject to the Fifth Amendment privilege, that would be a false statement. The privilege applies in very narrow cases, specific circumstances. So we're going to get into the nitty-gritty and delve deep into what those conditions are and what has to exist in order for the Fifth Amendment privilege to protect the act of producing documents. So, what does the act of producing documents concede? There are three main things. First, the existence of documents demanded. Second, their possession or control by the taxpayer. And third, the taxpayer's belief that the documents produced are those described in the subpoena. And that is a fact that is critical when it comes to the authenticating them at trial. We're going to get into that later on, and we'll have a robust discussion about how number 3 becomes in a criminal trial. So going back to the general rule, even though it's not a black and white rule and it's more or less a gray rule that is vague, this is a good rule of thumb to keep in the back of your mind. It'll help guide you through this choppy area, and that is that the compelled production of business documents may be protected by the Fifth Amendment. Now, every word in this rule, or every element rather, what we call them in the law as element, has a precise legal definition. And the first word here being compelled. We're going to go into the meaning of these terms, and discuss some case law that has been spawned area of document production to learn how the courts have interpreted these legal terms of art. So essentially, the definition that, or the first meaning that may pop into our heads when we think of compelled may not necessarily be the legal definition that was established by the courts. And of course, it's the legal definition established by the courts that guide us through this area. So beginning with compelled, the privilege applies only to compelled testimony. This is relatively straightforward. The definition of compelled is the same definition that you and I that would first come to mind when you and I think of compelled, and that is forced. So it should come as no surprise that voluntarily prepared documents are not privileged as no compulsion is present. The example that I give here is that a taxpayer who voluntarily produces documents in response to a summons or subpoena cannot later claim the privilege. In other words, buyer's remorse will not help the taxpayer challenge a summons after he has already produced the documents requested by that. Here's a good example to think of. Let's say, for example, that you have been pulled over for speeding, and let's say you've gone however many miles over the limit to earn you a fat speeding ticket. You get that the officer writes you that ticket, and it has a date that tells you you can go to court to pick it or to challenge it. You get home and you realize that that date is inconvenient, and you realize that you have too many other things to worry about right now, and so you just assume pay the ticket, get it over with, and move forward. So you pay the ticket, and you don't hear anything for some time, but then all of a sudden you get your auto insurance, you get an auto insurance bill in the mail. Premiums have gone up, and you start scratching your head and wondering what the cause for this was. Well, you dig deeper into the issue, and you learn that when you paid that ticket, essentially you admitted guilt to violating the speeding ordinance, and as a result, you have now 3 or 4 additional points on your license for speeding, and that of course translates into higher insurance premiums, or could translate into higher insurance premiums. So by paying that ticket and by trying to get it over with, you actually hurt yourself in another area that wasn't on your mind at the time. It unfortunately is too late to go back and undo all of that. You're now stuck with these extra, which could perhaps even have farther-reaching consequences if you already had a certain number of points on your license, including the possibility of license suspension. Okay. So in that case, the government served a summons on the taxpayer's attorney, requesting the attorney to produce work papers prepared by the taxpayer's accountant. Now, these work papers were initially in the taxpayer's possession, but then transferred by the taxpayer to his attorney during the course of the attorney-client relationship. The issue that the court decided was this: are the tax records of a taxpayer prepared by the taxpayer's accountant subject to the Fifth Amendment privilege against self-incrimination? Now, what I'm referring to here when I say tax records are the accountant's work papers, his own work papers. So that's a very important distinction to recognize here. The court held that these tax records, in other words, the work papers of the accountant, which were obtained through a summons on the taxpayer's attorney, were not protected by the Fifth Amendment privilege against self-incrimination. Well, why was that? The court gave us an analysis of why these work papers were not protected by the Fifth Amendment privilege. The court said that the summons and the order of the court enforcing it were directed against the accountant and not the taxpayer. The accountant's work papers are not the taxpayer's. They weren't prepared by the taxpayer, nor did they contain any declarations by him. Therefore, the essential ingredient of personal compulsion against an accused is lacking. So again, this whole concept of compulsion and forced request for documents is now rearing its head again in terms of who actually prepared the documents. And again, these were work papers belonging to the accountant and not to the taxpayer. And as a result, the court held that there was no personal compulsion against the accused. Now, what if the tax records were still in the taxpayer's possession? Would that alter the result in any way? And that was a question that the court considered in the opinion. They perhaps anticipated that there would be cases that came up later on asking just that question. Remember that in this specific case, the tax records were actually in the taxpayer's attorney's possession. But what if they were still in the taxpayer's possession? The court answered no, meaning it wouldn't matter if those tax work papers were still in the taxpayer's possession. However, the court did acknowledge two important things, and for our purposes, this is what's relevant. First, that the subpoena served on the taxpayer involved substantial compulsion. So the court acknowledged that the very fact of getting a subpoena and having this served on the taxpayer requiring him to produce an accountant's work papers in his possession involves substantial compulsion. And second, that the contents of the accountant's work papers might very well be incriminating. So these were two things that the court stipulated to. And again, this is slightly different than the facts of the case, because the facts of the case stated that the subpoena had been issued to the attorney. But in a similar or in a slightly different situation where the subpoena is served on the taxpayer, requiring the taxpayer to produce the accountant's work papers, the court recognized that there was a substantial amount of compulsion that exists, and that the contents of those work papers might well be incriminating. But the court said that the act of producing the work papers is all that the taxpayer is being compelled to do. It doesn't compel oral testimony. In the words of the court, it doesn't compel the taxpayer to restate, repeat, affirm the truth of the contents of the documents sought. So what does Fisher stand for? It stands for, among other things, the fact that the privilege protects only the act of producing subpoenaed evidence and not what the court calls tacit averments within the documents themselves. This case is basically responsible for expanding the Fifth Amendment privilege to include to protect document production. How about personal documents? What about personal documents that are in the taxpayer's possession? Are they subject to any claim of privilege? They are not. and that comes from the case of United States versus Doe. It's important to distinguish here personal documents from business records. Personal documents are not subject to a claim of the Fifth Amendment privilege. How about gathering, identifying, and authenticating documents? Could those acts be subject to a claim of privilege? Luckily, we have a case that answers that question. That's the case of U.S. versus Hubbell. U.S. versus Hubbell is an interesting, and it is worth noting and going into a little bit of the facts on that case so that you understand what the court was considering. In that case, the defendant was a Justice Department official who had already been convicted of tax offenses. On appeal, he challenged the conviction. The conviction was overturned. A special prosecutor asked the grand jury to issue grand jury subpoenas for a number of financial records. The prosecutor delivered an immunity order to the defendant, ordering him to comply and granting him derivative use immunity. Let's stop here for a second. What the heck does the court mean here by derivative use immunity? Well, we're going to get into that later on in the webinar, but for our purposes right now, it means that in the event that the government decides to prosecute the defendant, it has to show that that prosecution is based on information other than the testimonial information that the defendant produced and other than the leads developed from the testimonial information that the defendant produced. That's the concept behind derivative use immunity. Now, in response to this subpoena, to this grand jury subpoena, the defendant complied, and he actually went above and beyond by turning over 13,000 pages of documents. Based on documents produced, he was indicted for tax crimes and mail and wire fraud. So, what an odyssey this defendant went through. I mean, he went from originally being convicted of tax offenses to appealing the conviction to having it overturned, and then when he thought the thing was over and done with, a special prosecutor gets involved and asks the grand jury to issue grand jury subpoenas for a number of financial records pertaining to him. So essentially, the government launched a new investigation and demanded that he turn over a number of other documents, and with the caveat that he would be issued derivative use immunity, with that quote-unquote safeguard in place, the defendant turned over more than 13,000 pages of documents, and as his reward, he was later indicted for tax crimes and mail and wire fraud. So what was his argument when he went to court? His argument was the only way the government was able to bring this new prosecution was through the information that I produced. Keep in mind, in response to the subpoena, he provided more than 13,000 pages of documents. Do you think that somewhere in those documents there was a smoking gun, or that there was some critical piece of evidence that the government was able to use to indict him for these new tax crimes? Absolutely. And the court agreed with the defendant and held that the indictment should be dismissed. It's worth reviewing here the courts were dismissing the indictment. The court reasoned that the information was so voluminous that the prosecutor needed the defendant's assistance to identify potential sources of information and to produce those sources. Given the breadth of the categories of documents called for by the subpoena, the collection and production of the materials was tantamount to answering a series of detailed interrogatories or a series of deposition questions. And then the court basically explained what the defendant was required to do. He provided a catalog of the documents fitting within one of 11 broadly worded categories, and the court that could surely have provided a prosecutor with leads to incriminating evidence. In other words, the court held that the information that was relied upon by the government to bring this indictment was obtained through the very information that the defendant provided. Question is no. We're going to move on to immunity now. This is a fascinating area, and we just touched on it a little bit before in that case with derivative use immunity. Let's give a little bit of background on what is meant by immunity. It involves a situation in which a defense attorney who's representing a defendant tells the government something similar to this. Quote, "My client is just a little fish, but we can turn you on to some fish. But before we do that, we want immunity against prosecution." In other words, all right, I understand that you have evidence against my client that could lead to prosecution. But my client has information that could lead you to somebody higher up on the food chain, somebody who is more desirable than my lowly client, someone who you could make an example out of, and that could be splashed all over the headlines of the news media, that would really have a deterrent effect on the public from engaging in any, or from even thinking about engaging in any hanky-panky. But we give that a little something in return. What do we want? We want an ironclad guarantee that we won't be prosecuted. Well, that is a very simple way of explaining this. As you might imagine, there are various shades of immunity against prosecution, and we're going to get into those. But let's recognize a couple of things. How will the government respond or react to this request by the defense attorney? The government might be willing to do that, but it's rare when it comes to tax crimes. If the taxpayer's accountant is spinning lots of taxpayers into the webs and paths of deceit, the government will surely be more than willing to strike a deal. Or if it's a tax shelter investigation where there are big bucks involved, the government wants to go after not the investors. If the government wants information that would not otherwise be protected from disclosure under the Fifth Amendment, what can it do to meet the defendant's demands? Well, it can offer the defendant immunity. And if it were to offer the defendant immunity, that defendant would then have to turn over the requested information. Again, there are three types of immunity. There is transactional immunity, there's derivative use immunity, and use immunity. Let's talk about transactional immunity first. It's the gold plate standard. In other words, it is the best the defendant can get. It's the Rolls-Royce of all cars. This is what is most desirable or most desired by a defendant when he is tempting the government with this information. Transactional immunity means that the government won't prosecute the defendant for the offenses or transactions in question. As you can imagine, the government is very reluctant to grant full transactional immunity. Now, derivative use immunity. That is a middle ground. It's not as good as transactional immunity, but it's better than simple use immunity. What derivative use immunity means is that the government won't use information supplied by the defendant to prosecute him, nor will it use any leads that come from the information supplied by the defendant to prosecute him. But if the government somehow finds other information through independent sources, it may still prosecute the defendant, but it won't use quote-unquote this stuff or what's derived from this stuff to do it. In other words, the information has to come from an independent source. So if the government, notwithstanding granting derivative use immunity to a defendant, later brings a criminal prosecution, it must establish that the evidence that it's relying upon was obtained through an independent source and information supplied by the defendant or from any leads that come from the information supplied. As you can imagine, that is a very tough burden for the government to meet, as defense counsel can make a compelling argument that at the very least the information relied upon by the government has come from leads that the defendant provided in applied. To use immunity. This is the worst that a defendant can get. This is like that White Castle hamburger that you get that's full of grease and that can't compare to that sirloin steak that you would get at a five-star steak restaurant. The government says, we won't prosecute you on the information that you turn over to us, but if we discover other information based on the information that you gave us, then we'll prosecute you based on that. So use immunity protects the defendant against the use of some information, but not against leads derived from that information. So how do the negotiations go? Well, there will be posturing between the parties in which the taxpayer's lawyer, and most notably a defense attorney at this stage, insists that his client has information that the government badly needs. The attorney, of course, wants the broadest scope possible, and that would be transactional immunity, or, absent that, the best possible use immunity, derivative use immunity. The government, on the other hand, is not so willing to grant either of those. And so the defense attorney has to convince the government that the defendant has great information, has this bombshell of information that is going to help the government get to somebody higher up on the food chain. Not surprisingly, the opening offer by the government, it's generally use immunity. So what does a taxpayer's attorney do? Typically, he tries to tantalize the prosecutor with certain portions of his client's information, kind of like a preview, just like you would see in a on a TV sitcom series that is previewing the next episode, or on a cliffhanging CSI or Law and Order episode that's being continued into week number 2. They'll show you some previews from the sequel, and to entice you to come back on the same day and at the same time to watch the sequel and to find out what happens to so and so and how the case resolves. No different here. The taxpayer's attorney attempts to tantalize the prosecutor with certain portions of his client's information in order to convince the prosecutor that the government's need is greater and to induce the prosecutor to grant a higher level of immunity. One of two things happens: an agreement is reached or the negotiations fail. This depends upon how valuable the government thinks the information is. In addition to the three kinds of immunity that we've discussed, the prosecutor also has the ability to confer act of production immunity. So let's set the scene here. Let's suppose that the government really wants some documents that only the taxpayer possesses. But under Fisher, we know that the very act of turning over information can be incriminating. So what can the government do? It can grant the taxpayer immunity with respect to the act of production. What does that mean? It means that the government cannot use the fact that the taxpayer turned the documents over in response to a subpoena or summons to authenticate them. Once again, the government cannot use the fact that the taxpayer turned the documents over in response to a subpoena or summons to authenticate them. And so the next logical question is, if the government grants the taxpayer active production immunity, how will it authenticate the documents at trial? Now, what I mean by authenticate the documents at trial is this. How will the government show that the taxpayer possessed the documents requested by the subpoena and produced them in response to the subpoena? So authentication gets down to two key elements. One is possession and the second is production. Let's consider this example. Suppose that the taxpayer owns a corporation, and suppose that the government wants to introduce documents that it obtained from the corporation in response to a subpoena. Most likely, the circumstance would be that these documents incriminate the taxpayer in some way, shape, or form. These cases usually arise where the taxpayer is the sole shareholder of a small corporation and wears a number of different hats. How will the government show that the corporation possessed the documents requested by the subpoena and produced them in response to the subpoena? Well, I'll do with chain of custody. How can the government establish chain of custody? Chain of custody is nothing more than what we as lawyers refer to in court as establishing a connection for how evidence was passed along a chain from the time to the time it was seized by the police, to the time it was placed in an evidence vault in the police station, to the time it was carried to court and then introduced to a jury in court. So one example that I'd like to give here has to do with a street crimes case where drugs, say, on the defendant's person or perhaps in his car as a result of a traffic stop. What a chain of custody establishes is how those drugs came from being in the car or on the defendant's person to being presented in court exhibit during the course of the detective's testimony and being shown to the jury during the course of that trial. So there are various people that have been in possession of the drugs from the time it was discovered to the time it made its way into court for the jury to see. And that's the whole concept of chain of custody. It doesn't differ, not drugs. Well, the government can call two essential witnesses into court to testify and to establish this chain of custody. First, the process server who delivered the subpoena to the corporation. That would be the government's first witness. Second, the individual in the corporation who received the subpoena, that being the custodian of records. So the equivalent in a street crimes case would be the police officer who seized the drugs from the defendant and then gave them to the detective who brought the drugs to the police station and stored them in the evidence locker. And then finally, perhaps a different detective who opened up the evidence vault and brought the drugs from the police station to court for the defendant's trial. Again, here the only difference is we're dealing with documents and not drugs. So the two witnesses would be slightly different. Again, the government would introduce the testimony of the process server who delivered the subpoena. The process server's testimony would introduce the testimony of the custodian of records, who is the person within the corporation that received the subpoena. Infer something, and that is that the corporation possessed the records and that it produced them in response to the subpoena. Now, there's this case of Braswell versus United States, which is quite interesting. It is a case that deals with a similar situation to what we just talked about, where the taxpayer is actually the sole shareholder of a small corporation. And as the sole shareholder of the small corporation, the taxpayer wears hats, from being the marketer to being the product developer to public relations to custodian of records. And so the issue that came up in this case is, can the custodian of records claim the privilege under the act of production doctrine on the grounds that his act of production would be personally incriminating? In other words, this contemplates that the very person who is the custodian of records is the defendant / taxpayer himself. The argument that the taxpayer made in this case is any production by the corporation would surely be viewed by the jury as having been done by me because, after all, I'm the company's alter ego. I'm the only one running the show here, and any action by the company is going to be attributed to me. The custodian of records, even if he happens to be the taxpayer himself, cannot claim the privilege for active production cannot claim the privilege for active production on a personal basis. Let's talk a little bit about Castigar hearings. A Castigar hearing is not some crazy term that courts invented for a hearing. It simply comes out of a case. The case is named after Castigar. And what does this hearing have to do with? Well, it's to do with derivative use immunity. It's a pretrial hearing that's filed by defense counsel. And it answers a critical question that comes up when it comes to immunity. And that is, was the information used by the government to initiate a criminal prosecution Was that information based upon leads that the government developed through information already to the taxpayer, or was it obtained independently? This gets back to what we were talking about earlier. Now, there are a couple reasons why the government detests Castigar hearings. The Castigar hearing is the main reason why the government resists conferring derivative use immunity by agreement. If the government confers derivative use immunity, later on it must go through a Castigar hearing. Remember that we talked about how difficult a burden it would be on the government to prove that the information it's relying upon to indict a defendant was independent of any information that the defendant provided, or independent of generated by the information that the defendant provided. It's very easy for a defense attorney to point out one or more documents, and from those documents extrapolate that the government learned of information and new leads that it followed up on and that resulted in the new indictment. So it's very hard for the government to prove had an independent source for the information that later led to the defendant's indictment. Attorneys love to file these pretrial hearings and have Castigar hearings. And it's sometimes analogous. Most government attorneys and assistant U.S. attorneys refer to it as a fishing expedition. Even if the government wins the case, information will be revealed that would give the defendant additional discovery that otherwise wasn't available. And just as a way of background information, discovery tends to be very narrow and scarce in criminal cases, especially in the federal system. So the Castigar hearing might be a strategy employed by the defense to learn more about the government's case, a veritable fishing. And I can tell you from experience that, and having been involved in a number of criminal cases, defending individuals in federal court, that it does live up to its reputation as providing additional discovery to the defense and is a very useful tool from that perspective. To end our third webinar, and it will end the first. It will take us through the second topic on privileges. It will take us through the second topic on privileges. So we will now embark in webinar number 3 on the third and final privilege to IRS summonses and subpoenas, and that is the attorney-client privilege and the work product privileges. It will include a robust discussion on Covell agreements, which I know everybody is looking forward to. I've had a lot of feedback on that. If you have any questions about anything that's been covered thus far, please contact me. Don't hesitate to call me anytime. My work number is up here on the slide, as well as my email address and website. I'm willing to help you in any way I can. If I don't have an answer to something, then I'm happy to research it and get right back to you with an answer. So it's been great going through these first few webinars, and I look forward to seeing you in webinar number 4. Stay well.